From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court pulls the drain on the Environmental Protection Agency's overreach on wetlands regulation as a new analysis warns of a risk of widespread electricity blackouts and brownouts this summer. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Let's start at the Supreme Court. There is a landmark case there on the Clean Water Act and a significant controversy over the last several years involving the waters of the United States. Alicia, can you give us a sense of what this ruling was about and the significance of it?
So this ruling was about the Clean Water Act. It's a 1970s era law that allows Congress, or in this case, Congress delegated its power to the EPA and the U.S. Army Corps of Engineers to essentially regulate interstate commerce, navigable waterways, which are defined as the waters of the U.S. It's a very kind of amorphous term. And over the last several decades, this has been litigated. What does the waters of the U.S. mean? How far is its scope? Again, the EPA and the U.S. Army Corps of Engineers have generally interpreted their authority very broadly and have steadily encroached on more and more land, not just wetlands initially, but then they start to interpret it to mean, say, land that could temporarily fill with water during floods or, ditches, drains, and such. And this was particularly pernicious under the Obama administration. And they adopted opinion by Justice Anthony Kennedy in the case known as Rapinos in 2006 that gave the EPA the authority to regulate any land or water. It doesn't actually have to be wet. That has a significant nexus to another body of water that it can regulate. And this was, again, it's very amorphous. What does that mean exactly? Significant nexus. The EPA has interpreted it, again, very broadly. This went back and forth with the Trump administration, rolled back much of the Obama rule, but then the Biden reimposed it. And that was basically the core of the issue in this case, is the extent to which the EPA and the Army Corps of Engineers can regulate land or water that isn't even water in this case. There was a couple, Michael and Chantel Sackett, who've been trying to build a home on property in Iowa near Priest Lake for 16 years. And when they start construction and move dirt on their land, the EPA basically swooped in and said, you need to get a permit for this. And this case has already actually gone up to the high court before, in which they argued that, they should be able to challenge this before actually being penalized. And so this is actually the second time that they've actually been up to the Supreme Court to challenge the EPA's authority or the overreach. And so at the very root, this is a case about, both the separation of powers in terms of how broadly the administrative state can regulate without an explicit delegation or explicit authority from Congress. And then, of course, federalism, because states traditionally have the authority to regulate these lands within their borders that are involved in interstate commerce.
The key words in the Supreme Court's previous cases on this topic, and Alicia said them, but they're significant nexus. So this is a couple in Idaho. They purchased this lot near Priest Lake and were going to build a home on it, started backfilling the property. I'll read a line from the majority opinion here by Justice Samuel Alito. He says, according to the EPA, the wetlands on the Sackett's lot are adjacent to, in the sense that they are in the same neighborhood as, what it described as an unnamed tributary on the other side of a 30-foot road. That tributary feeds into a non-navigable creek, which in turn feeds into Priest Lake, an interstate body of water that the EPA designated as traditionally navigable. And so according to the EPA, that means that the lot owned by the Sacketts is in a significant nexus with Priest Lake. But it's a little game of leg bone connected to the arm bone here. You have wetlands on their property, a 30-foot road, then an unnamed tributary, then a non-navigable creek, then Priest Lake. And if you start getting that far from the actual authority in the law of the law passed by Congress to regulate the waters of the United States, the navigable waters, then you start to wonder how far that EPA authority does go. And Alicia, does the majority pare back that interpretation of significant nexus? And also, now I note that it's a 5-4 opinion here. Justice Brett Kavanaugh breaking with the majority. And what was the standard that he wanted?
So all 9 justices ruled for the Sacketts and said that the EPA doesn't have their authority to regulate this land or require that they get permits to move some dirt on their land. And actually, all 9 justices disagreed with the significant nexus test, which isn't actually terribly surprising because if you go back to the Rapinos opinion in 2006, the significant nexus was really a lone opinion by Justice Kennedy. The liberals didn't join in, the conservatives repudiated it. And the conservatives, in this case, 5 of them at least. Again, we can get to Justice Kavanaugh's opinion later. But 5 of them basically adopted the conservative plurality's opinion in Rapinos, which would allow the EPA to regulate the waters that are relatively permanent, standing, or continuously flowing bodies of water, such as oceans, rivers, and lakes, and then wetlands that were directly adjacent and indistinguishable from those waters. Now, where Justice Kavanaugh sided with the liberals is he thought that the adjacent should be read or interpreted much more broadly and that it doesn't have to mean directly adjoining, and that he thought that, well, adjacent could mean a dictionary definition, close by, neighboring, or nearby. It doesn't have to actually touch. And so there was a disagreement between the 5 conservative justices and then the liberals and Justice Kavanaugh on what exactly the word adjacent should mean. And I think the conservatives came out on the right end of this in terms of there would be no limiting principle if you were to define adjacent as anything that was close by or nearby. That means the EPA could essentially regulate any land or water that it wanted to. It just had to say, well, this is close by an ocean. This is, nearby Lake Michigan. And this could actually be much more broader authority than even the significant nexus standard.
Kim, a lot of the analysis or the coverage of this opinion have said that it's a loss for the Clean Water Act, a danger to America's waters. But to me, this looks like one of those cases about who decides. And there's nothing about this that precludes state regulators, which have broad authority over the waters in their lands. And by the way, a real interest in keeping those lands clean, since they're the people who are actually living around these rivers and wetlands and lakes that we're talking about often. There's nothing that precludes them from making more stringent standards, passing environmental laws through those state legislatures. And also, there's nothing that prevents Congress from giving the EPA more power if it thinks the EPA needs that power. What we don't want is to have a broad language passed by Congress, waters of the United States, navigable waters, and then to have the EPA or another agency aggrandize their power and be making decisions that they are not really authorized to make.
To be clear, the hysteria that you are hearing from many on the left is exactly that. It's just hysteria. The Clean Water Act has been on the books for half a century. The United States has made massive progress using it to clean up some waters in the country that really did deserve some attention. That's a very different question from what's happened over the last 10, 15 years, where this was just a land grab by the EPA and the Army Corps of Engineers, portrayed by Democratic administrations and bureaucrats that wanted to extend their reach. We're talking about tens of millions of acres that they were saying that they had enforcement authority over, when the clear text of the Clean Water Act did not really do that. Now, I understand how they managed to get away with it because of some of these opinions, as Alicia mentioned, Rapinos, in which Kennedy put forward this very murky standard that bureaucrats then drove a bulldozer through. But all we are having here is the Supreme Court putting people back in their lanes, just as they did last year with the West Virginia EPA decision with regard to power plants, telling bureaucrats that there are limits to what you can do. And indeed, as you just said, Kyle, that if you don't like those limits, then you need to go to Congress and have Congress rewrite the law. And Congress can do that if they think it's necessary. I think that the necessary thing is really important, because one of the points that comes out of this Alito decision is that the way that the EPA was interpreting this really was exerting authority over areas of land that are not wetlands, okay? You have a soggy backyard for a season because it was wet that year. Somehow the EPA was saying that made it the case that you had wetlands in your backyard and you couldn't do anything with your yard. And to be clear, just how corrosive and punitive these standards are. When the EPA exerts authority, you basically can't do anything with your property, okay? You can't build, you can't backfill, you can't use herbicides, you can't use Roundup on your weeds. It suddenly is this protected area and the permits are not given out for the most part. So yeah, if you don't like it, go to your state legislature, go to Congress, ask them to rewrite it. But nobody can fault the Supreme Court for saying, hey, this is what the law says, stick to the law.
So, Kim, does this Supreme Court decision, do you think, obviate the need for any kind of legislation, or are clearer definitions from Congress still useful? And I would note that one of the Republican permitting bills that was recently introduced, this one is the Restart Act, has some more clear and specific definitions for some of these things. So, skipping over some legalese here, for example, it says an adjacent wetland is a wetland that touches at least one point or side of a body of water, or is inundated by flooding in a typical year from that body of water, or is physically separated from that body of water only by a natural berm or an artificial dike, something like that. And so, Kim, I think the regulatory agencies often overstep, and the EPA probably did here, but it is also true that part of the problem is that Congress originally passed, as it is in the habit of doing, these statutes with unclear and vague language, such as waters of the United States. And now here we are, and the agencies are running with that as far as it will go. And we're here in court now trying to rein them in, whereas maybe what we really need are some specific definitions like what is in this permitting bill.
Clear language is always appreciated from Congress. It's just not very good at it and hasn't been good at it for decades now. And I think this is part of the message from the Supreme Court is do your job. We've seen a tendency, especially in the last decade again, for Congress to sit back, often purposely under Democratic majorities, write very vague statutes because they want the bureaucrats to have the ability to then define them the way they want to, because they know the administrative state is largely on their side. So yes, more specific language would be good. I am doubtful that may happen only because this permitting reform that you were talking about, while there is a little bit more bipartisan interest in it these days, there's still a lot of progressives that would reject any of that outright because they want, again, the administrative state to be able to exert authority over basically any piece of land in the country. All that being said, I would also point out, though, that one problem, especially with prior courts, is that even when Congress is pretty clear, things can still get muddy. And I would encourage people to go read Clarence Thomas's dissent in this piece, which basically makes the point that once the courts actually kind of sign on to something, even they are wary of rolling it back. And, he notes that the operative text in this operative law is the word navigable waters. That does not necessarily include wetlands, even if they are touching navigable waters. And he would have gone much farther. Gorsuch joined him in that, in saying that actually Congress said you can only regulate navigable waters, not the things near them, adjacent, touching, etc. Now, I would wager that the reason you didn't get 5 votes for that is that even Alito and Roberts and Amy Coney Barrett probably weren't willing to go that far, to be that far of a rollback of where we have landed at the moment. But that's kind of a pity. That was the pity to me of the decision, is that as good as it is, it's not really going back to the real text of the Clean Water Act. And so I think the lesson here is Congress needs to be more clear from the start. Sometimes it needs to actually go out of its way to define what things really mean on top of the words. And maybe we could avoid some of these issues going forward if it was a little bit more proactive on that front.